All right, Ms. Rodriguez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge.
Okay.
The officer initiated a traffic stop after observing the defendant's vehicle traveling 94 miles per hour in a 65-mile-per-hour zone. The officer observed an odor of an alcoholic beverage, and the defendant admitted to the officer that she had 2 drinks. Standard field sobriety tests were conducted. HGN 4 out of 6, walk and turns 5 out of 8, one leg stand 2 out of 4. The DIC was read and breath was refused.
Quick breakdown: speeding, odor of alcohol, admitting to 2 drinks, failing some sobriety tests. But here's the kicker: none of this automatically equals intoxication in court. Should speeding and 2 drinks be enough to escalate things this far? What do you think?
A blood search warrant was signed and executed.
Felt like that went really fast. So the stop was for speeding.
For speeding, yes.
Then,
And then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank 2 beverages.
just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
I know that while the SFSTs were, this is for the Jams, while the SFSTs were being conducted, she was not understanding, like the officer to explain, I think at least 4 times the instructions for the walk-in turn, the one-leg stand. He also noticed that I think she took off her boots for the one-leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, I just an odor, not even a strong odor at that, you know. And then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? You know, there's no accident here. There's no. Is she a Spanish speaker?
I believe so, Your Honor.
I don't see any indication of that.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her. I mean, which is per, you know.
But
procedure for
right, I
SFSTs,
get the SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough. An odor of alcohol in and of itself is insufficient.
But
Yeah.
it seems that this stop occurred at 2 in the morning, and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period between when she's finished drinking and then
alcohol dissipates every 1 hour, and alcohol.
And there it is. The judge throws out the case for lack of probable cause. But notice how he immediately pivots into a lecture about the dangers of drunk driving. He's basically saying, legally, I can't hold you, but morally, you need to do better. Do you think that's fair, or is it guilt tripping after the fact?
All drink dissipates from your system.
she still had the odor in addition to that statement.
All right, I'm going to find no probable cause.
Yes, Judge.
Ma'am, be careful, you know, really. Every single day, someone dies from a DWI in our county. It's so easy to take a $20 Uber, literally push one button. You have a car waiting for you wherever you want to go in this county. Do you understand?
Yes, sir.
Right. Please take a seat. Good morning, Ms. Treadwell. How's jail? You know, your lawyers come up to me and ask for me to reduce your bond. I've got your bond at a very high rate, you know, $50,000 for a reason. I want you to understand that we mean business. It's not a joke. When you're out there and you're driving in a state that can, very well, you may do something that can cause catastrophic damage and you'll never dig yourself out of a hole. I will reduce your bond. They asked me for 5, I'll do 7,500 each. But I'm telling you, if you do get out, no more issues. I want you on the curfews, and I don't want you out in the middle of the night, and I definitely don't want you driving. You understand? You're going to have to find another way to make it work, but not in a car. I just can't trust you. You have a lot of people that depend on you, 2 children that depend on you, right? When you're not there, they're going to look to love and support from somewhere. And if you're not there, they may look to it at places you don't like or you don't approve of. These are things that you need to consider. When you become a mother, your life's not yours anymore. It's your children's lives. That's who matters. So when you're out there considering doing what you're going to do, the only thing that needs to come in your mind, if I do this, how is it going to impact my kids? That's what you need to be thinking about. Do you understand, man?
Yes, sir.
Okay. I'll make it 7,500 each. Okay. And then if you're able to bond out, you must come here immediately so we can do all the bond conditions, do all the paperwork, because I'm putting an ankle monitor on you so I know where you are. And I'm on your other ankle, I'm going to put a scram so I know that you're not consuming alcohol. And I'm going to tell you now, you bond violate, you consume alcohol again. You pick up a new case, holy, I'm going to go nuts on the bond. Do you understand? Okay, Mr. Treadwell, good luck. Okay, guys. Thanks. Thank you. You are Noah Montgomery. Mr. Montgomery, you're charged with criminal mischief. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On October 27, 2024, the officer dispatched to a residence in reference to a criminal mischief in Harris County, Texas. After the initial investigation, the officer had found the defendant had left the residence, walked several streets over, and vandalized the complainant's motor vehicle. The defendant damaged the driver's side mirror by using hands to pull on and break the mirror in several places. The defendant used a knife to strike the windshield in a stabbing motion, causing damage. The damage was approximately $1,000. The complainant's daughter showed the officer a text where the defendant admitted he damaged the motor vehicle and planned on damaging the motor vehicle again in the future. The defendant was found at his residence and a bent kitchen knife was located next to him on the ground.
Okay. Mr. Montgomery, I'm going to find that there's probable cause to go forward with your case. So what was the relationship, Alex?
Relationship, they are neighbors, Your Honor.
Just neighbors?
Yes, Your Honor.
Do we have any kind of allegation of alcohol or any kind of dope usage?
No, Your Honor.
Never? Okay.
No allegation. Pass.
Mr. Montgomery, like I said, I'm going to find probable cause to go forward with the case. I'm ordering you as a condition of your bond not to go within 200 feet of where this person lives or where this person works, not to be in possession of weapons and not to have any contact with them. Do you understand? If I find that you violate this condition, I will put you in jail in a moment's notice. I will do everything in my power to protect every person of Harris County. Do you understand? How old are you, sir?
Whoa, this judge just shifted gears from property damage to suddenly becoming this teen's life coach, probation officer, and high school guidance counselor all in one. Question for you. Should judges step into a parental role like this, or is that overstepping the bench?